Hello. This presentation will be about Minnesota's felony murder law, which imposes strict liability on defendants for any death that occurs during their commission of a felony. In simple terms, if you commit a felony, for example, a robbery, burglary, or assault, and someone dies during the act, all defendants who participate in the felony can be charged with murder and receive decades in prison. It doesn't matter if they harmed the victim themselves. Felony murder law reform has become a nationwide movement over the last few years, and accordingly, Minnesota commissioned a state task force to study the issue. Their report spans over 200 pages, and so, in an attempt to make that more digestible, we hope to summarize their work in the next 10 minutes. This report was authored by Wilder Research. We'd like to start with a story that illustrates the problem. Do note that for this story and others, we will use aliases, not the defendants' real names. In 2017, Jordana and Juliana made plans to retrieve medication they believed had been stolen by a friend. They and a couple of others went to the apartment to retrieve the medication. One of the others brought a gun and held the girls at gunpoint. They were forced to lie on the floor as the man shot the victim in another room. Jordana and Juliana were 19 and 20 at the time. The girls were ultimately arrested and charged with aiding and abetting first-degree felony murder. Retrieving an item from someone's house without consent is felony burglary under Minnesota law, and someone was shot during the course of that burglary. They were each facing life in prison without parole. Their attorneys fought till the day of trial, but each ended up taking a plea deal for 13.5 years to avoid the risk of life imprisonment. You can read more about this story and others at fmlr.org. It was stories like these that prompted the Minnesota State Legislature to create a task force in June 2021. The task force was bipartisan and formed of prosecutors, defense attorneys, members of the Minnesota County Attorneys Association, and activists, who all had different perspectives on felony murder. The task force was split into 3 different subcommittees. First, one that collected and analyzed data. Second, one that looked at case law and trends in the felony murder rule across the 50 states. Finally, there was a subcommittee that heard from victims, defendants, and others impacted by aiding and abetting felony murder. In November, the task force hired Wilder Research to synthesize their findings into a report we are discussing now. To read the full report, you can visit the task force website. To understand the data collected by the task force, it's important to understand the distinction between aiding and abetting felony murder and bringing the principle of felony murder. The task force was primarily concerned with aiding and abetting felony murder because defendants can be punished for murder without having taken deliberate action to kill someone. However, complicating the data collection process, principals and non-principals were often both charged with aiding and abetting felony murder. The task force was interested in the difference between the sentences for those who were principals and for those who were aiders and abettors, as opposed to people arbitrarily charged one way or the other. Looking through the criminal complaints that detailed the events of the crime, the task force found 4 instances where principals received shorter sentences than those who aided them. The task force also looked at the demographics of those convicted with felony murder. Ultimately, the task force found that Black people, people from Hennepin County, and young people are largely overrepresented, causing concerns that the broad discretion allowed by the doctrine leads to unequal punishment based on race, place, and age. The task force is concerned that due to the large geographic differences, people who behave the same are charged differently depending on the county where the acts occurred. As part of its mission, the task force collected input and stories from defendants convicted of felony murder. One person, convicted at age 16, recalls that it was terrifying growing up in an adult prison. My friends would be going through it, be breaking down crying, and I can't hug them because I'd get sent to SEG. Another impacted person, who was 19 at the time of the incident, says, "It's impacted me mentally and emotionally. It's hard to look in the mirror. And getting here when I was so young, I don't think I understood how young I was until I walked in the doors. I felt so little and small and weak. I never wanted my mom more." The task force also heard broad consensus from victims' families, victims' advocates, and impacted people that they support broad reforms to limit aiding and abetting felony murder liability such that aiders and abettors are not culpable for the homicidal acts of another. Minnesota Alliance on Crime member organizations overwhelmingly support comprehensive, retroactive overhaul of Minnesota's aiding and abetting felony murder doctrine. They also support abolishment or comprehensive reform that holds aiders and abettors liable only for their factual contributions. The task force interviewed 11 family and friends of victims. Almost all supported revisions to the current law for aiders and abettors. Almost all supported a retroactive process for relief. Another important contribution of the task force was its review of felony murder law in the 50 states. Note that the task force, due to limited resources, was only able to look at decisions of the legislature and state supreme courts, not all case law in a state. It found 6 states with primary limits, meaning limits that severely restricted the scope of people who could even be charged with felony murder. 5 states completely abolished felony murder, 2 through the legislature, and 3 through Supreme Court decisions. Under these restrictions, most aiders and abettors would not face murder charges. Some states have laws that implement third-party liability. This means that if someone is killed by a third party during a felony, the accomplices can be charged with murder. For example, if 2 people are robbing a bank and one of them gets shot by a police officer, the remaining robber can be charged with his murder. Besides primary limits, many states also instituted affirmative defenses or secondary limits, which don't stop one from being charged, but give them defenses they can raise to lower liability. Minnesota, for example, has an abandonment defense where defendants can prove they abandoned the scene of the crime. However, these are not silver bullets. The story of Jordana and Juliana proves this. They were held at gunpoint and could not raise an abandonment defense. Using these findings, the task force unanimously recommends that the Minnesota legislature consider 1. Revising relevant statutes such as those who aid and abet felony murders are not liable for murder where the aider and abetter did not A. kill another, B. otherwise contribute to the homicidal acts of another while intending to kill, nor C. act with reckless disregard for human life as a major participant in a felony where a human died. 2. Revising relevant statutes such that people previously convicted of aiding and abetting felony murder may petition the court for relief. 3. Implementing reforms beyond mere adoption of an affirmative defense for aiding and abetting felony murder. The task force recommends against mere adoption of an affirmative defense on principle, because shifting the burden of proof to a defendant to prove their innocence is in opposition to a vast majority of criminal law. To learn more about the task force work, please visit the Aiding and Abetting Felony Murder Task Force at mn.gov. To hear defendant stories, learn more about felony murder law, and to support reform efforts, please visit fmlr.org. There you can find links to petitions, educational videos, and get up-to-date information about the fight to reform felony murder laws.